Good morning, ladies and gentlemen.
Morning, Julia. Our attendees are on mute, so I don't think they'll be able to respond to you. Good morning, everyone. Our facilitator for today, Julia Masike, just dropped off. I think she's been able to rejoin us. Sorry about that.
Thank you so much, Kia. I'm back. Blame it on load shedding. Can you hear me?
Yes,
Yeah?
can hear you.
All right. Can you see me?
Yes, we can see your beautiful face.
Thank you so much. Good morning, ladies and gentlemen. I would like to extend a warm welcome to principal officers, trustees, administrators, officials at local authorities, and my colleagues at the FSCA. Thank you for making time to be part of this webinar on contributions in terms of Section 13A of the Pension Funds Act. I'd like to also thank our speakers for taking time to participate in this valuable initiative. My name is Mambi Julia Masike. I'm an analyst in the Retirement Funds Conduct Supervision Department at the FSCA, and I will be your facilitator for the webinar today. Last year, the FSCA hosted webinars on bargaining councils and municipal funds. And this year, our focus is on commercial umbrella, sectorial determination, and trade union funds. You may ask why we've decided to separate the various funds. Well, we felt that having fund-specific webinars would assist us in highlighting key issues for funds operating in the same space or sector. Non-compliance with Section 13A is a huge problem in our retirement fund sector. We know there are various issues facing employers in our country. Therefore, we meet today to discuss the regulatory framework to ensure the fair outcomes for members of retirement funds are indeed achieved by all stakeholders involved. This is the last installation of the batch of webinars hosted by the FSCA in relation to Section 13A of the Pension Funds Act. Today is part 1, which will speak to the regulatory framework, and part 2 will then focus on the practicalities of it all.
Julia?
We hope, hi, Takia.
I'm sorry to interrupt you. I see we have attendees who say they can't see your face. They can only see the agenda. So can you switch off your camera and then switch it on again? Let's see if that works.
Are you able to see me? I can see in the comments that they can see me. Are you able to see me, Kia?
Yes, I'm able to see you. All right, I think, sorry about that. You can proceed.
Okay, thank you so much. So this is part 1 of the webinar, which will speak to the regulatory framework, and part 2 will focus on the practicalities of it all. Just a few house rules before we start. The webinar will be recorded. You're welcome to post your questions or comments on the chat function or make use of the hand function in case The production team will obviously let you or unmute you to ask your question. The speakers will, time permitting, answer questions at the end of their respective presentation, and they'll also have an opportunity to participate in our Q&A session as reflected on the agenda. Presentations will be made available on the FSCA website, and the recording of the session will be made available on the FSCA South Africa YouTube page. Please, we ask you humbly that you, at the end of the session, complete the feedback survey that will be shared on the chat function. Lastly, we'll break at 10 o'clock for 15 minutes and again at 11:45 for a 30-minute lunch break. Thank you, and I hope you enjoy. To officially now start the program, I would like to call upon Ms. Lukhaimane, Takalani Lukhaimane, to the virtual stage to deliver an opening address. Ms. Lukhaimane is a manager in the Retirement Funds Conduct Supervision Department, and she's spearheading the FSCA work around Section 13A. Ms. Lukhaimane, can you take over the virtual stage, please?
Good morning, and thank you so much, Julia. When you started initially, I thought, oh my goodness, she's saying everything that I actually need to say. So I was getting a little bit worried. But I am so grateful to see such a great turnout for this webinar. Ladies and gentlemen, and distinguished guests, and sometimes because we don't interact with you as much, as distinguished guests, we forget that in actual fact, you are people or you are stakeholders that need to be treated as well as our distinguished guests from time to time, outside of coming to the office and having meetings. I just want to make sure if everyone can see me and my background is fine. If I could get a thumbs up, Julia, then I will get going.
We can see you, Ms. Lukhaimane.
Thank you so much. Thank you so much, everyone, for making the time today for this first installment, as Julia said, of the Section 13A webinar for commercial funds and our union funds. We are pleased to have such a high turnout and hope to honor your expectations for this session and the ones to come. Arrear contributions and unpaid debts owed to retirement funds have emerged as a pressing concern for our industry. And the FSCA decided that we needed to have a proper strategy around addressing arrear contributions. And as Julia mentioned, when we looked at the issue, we decided that we needed to address separate funds in terms of their functioning and their structure in different ways to make sure that we can customize the solutions that we come up with. It is a matter that demands our immediate attention and concerted action to safeguard the financial security and dignity of our members, both in the present and in their retirement funding years. You would know better than anybody else that for most South Africans, their retirement fund savings is the only savings that they actually have. And it is vital to supporting our economy in terms of their post-retirement and not having too much reliance on the state to provide for retirement funding as well. Retirement funding is a vital source of income for millions of South Africans. It provides safety net and ensuring that individuals can enjoy a decent standard of living and maintain their independence during retirement. This cannot happen without contributions going into the retirement fund timeously in order for it to be invested and in order for there to be benefits that can be paid out at the end for retirement. When contributions go unpaid, the stability of these funds is compromised, jeopardizing the financial security of all members. The reasons for arrear contributions are varied and complex. They can arise from economic hardships faced by employers. Our current economic situation and the pandemic have certainly had a great impact on employers. There is, of course, inadequate financial management and just deliberate non-compliance. Regardless of the causes, The consequences are far-reaching and are both affect both the employers and employees alike. Employers have a legal and moral obligation to ensure that their employees' retirement fund contributions are paid in full and on time. By fulfilling this duty, employers not only protect their interest of members, but also contribute to the overall stability and sustainability of our retirement funds. So treating employers as a vital and valued stakeholder in this process, especially in our commercial umbrella funds, is of utmost importance. Equally important is the role of employees themselves. It is crucial that individuals remain vigilant and informed about their rights and entitlements regarding retirement fund contributions. I can certainly attest to the fact that more and more we are receiving complaints from members wanting to establish why retirement funds have not done anything about their employees or their employers not contributing to the fund. By staying informed, employees can hold their employers accountable and take appropriate action if arrear contributions occur. This can only happen if there is proper communication from retirement funds to their members, and timeous communication is vitally important. Additionally, financial literacy programs can be instrumental in empowering individuals to make informed decisions about their retirement savings and take proactive action to secure the financial well-being. For those funds that have your management committees at your participating employers, and have proper communication strategies to ensure that you keep your members informed, we implore you to continue those and to strengthen those in order to ensure that members are informed about their retirement benefits. Furthermore, it is important for us as the FSCA to strengthen our regulatory framework to address arrear contributions effectively. This includes stringent enforcement measures, penalties for non-compliance, and improved mechanisms for monitoring and reporting. I know we are not very far with the enforcement measures and penalties for non-compliance, but it's certainly not something that we are giving up on. And you will see when we go through the webinars that there's a lot of effort being placed on what can we do to try and ensure that our enforcement mechanisms are actually effective. And any suggestions that come from this webinar and from previous ones are actually also being implemented, especially from the previous ones. Conduct Standard 1 of 2020, which will be covered in detail during the webinars, has made improvements to the previous regulations to assist funds in gathering the appropriate information and to follow the right steps for enforcement. We intend on publishing the names of employers that have contravened the provisions of Section 13A, and some of you have already received letters requesting information in this regard. Retirement fund trustees play a pivotal role in the collection of arrear contributions. The Board of Management must ensure that there are proper procedures in place to monitor and report arrear contributions, and the board creates a great link between our office, service providers, and for members. In closing, addressing the issues of arrear contributions requires a collective effort from all stakeholders involved: government, employers, employees, retirement fund trustees, and retirement fund administrators. This webinar is to open dialogue and not just to provide information. We are committed to finding solutions for arrear contributions that ultimately provide good outcomes for members. We have invited criticism in previous webinars, and we will continue to do so because we do want to honor our policy of having an open door in order for us to create an environment where everybody's contributions are heard and feed into policy when we are addressing these issues. Thank you very much, and happy Nelson Mandela Day. I hope that you enjoy the webinar, and please, any questions and any suggestions going forward for how we can continue to engage with you as our stakeholders are more than welcome. Thank you very much.
Thank you so much, Daki, and happy Nelson Mandela Day. Thank you for a great opening, and obviously thank you for giving an overview of the work that is, done by the authority. And I must say the industry has been very welcoming to the initiatives taken by the authority. We'll move to our first speaker for the webinar, and he's none other than Mr. Tando Mbono. He's a manager in the Fund Governance and Trustee Conduct Department at the FSCA, and he'll be covering what the implications of the legislation are. So basically, he'll be giving us a legislative landscape discussion. Tando Mbono, can you please take the virtual stage?
Morning. Thank you, Julia. Can you hear me?
Yes, I can.
I'm sorry, Mandy, if I've just had a crisis. My presentation just acted up on me. And good morning, everybody. I must apologize for the aesthetic of these slides, but I promise to have them fixed as soon as they are to go out. Murphy's Law dealt me a blow this morning. I hope you can sympathize. And if my voice sounds a bit shaky, it's only nervousness. It will go away. So as a point of departure, I just wish to outline the areas that I'll be touching on in respect of the legislative landscape in relation to contributions. So I'm going to be dealing briefly with Section 13A of the Pension Funds Act and the Companies Act in relation to business rescue of companies under financial distress, and draw some analogies, for instance, between the Companies Act and the Municipal Finance Management Act, to the extent that some of your member participating employers may be municipalities. Just a short outline of that. So as you know, belonging to a pension fund is a condition of employment where an employer participates in a fund.
Tando,
And sorry,
can I ask you to please have the presentation on presentation mode, if possible?
So that's what I was saying. I've trouble with the slides. How do I present that, Julia? Can it not be seen? Is it unsightly?
No, we can see the presentation. We can also see the slides on the side as well.
So I must change the mode to show just one slide.
Yeah.
Okay.
Yeah.
Hi, Tando.
Hello, yeah.
You can press F5 on your keyboard there.
F5, which I have.
There you go.
All right, so I'll just scroll down. Okay, thank you.
Yes.
Thank you kindly. So I'm sorry about that. So as I was saying, that is a condition of employment in circumstances where the employer participates in a fund. And I wish to say that up front, just to poison your minds for what is going to come a little bit later. So Section 13A of the Pension Funds Act regulates the payment of contributions by an employer to a fund in relation to any deductions made from the employer's salary or any contribution for which the employer is itself liable. And the time frame within which that must be submitted to the fund is 7 days after 7 days of the succeeding month to the one in respect of which the contributions are payable. So when employer fails, for instance, to deduct contributions as required by Section 13A, it has been found by the FST, for instance, that failure to deduct is the employer's own failure, but it cannot be used as a defense, for instance, against an application that is brought by a fund, in recovery of arrear contributions. So if you don't deduct, you are in the first place in breach of the act for not deducting. But if you have not remitted, you are still liable for an application that may be brought in recovery of those contributions. So in circumstances where employers don't deduct contributions, or they deduct but they don't make the contributions to the funds, in the matter of the Post Office, for instance, Retirement Fund versus the Post Office of South Africa, it was argued that because the employer does not have money, and it has, as a result, not deducted contributions from the employees' contributions, the liability of the fund, no liability attaches to the fund as a result of that. And that matter went to the High Court, which the court agreed, for instance, the High Court agreed that where the employer does not have money, it can defend itself by saying that the requirement to deduct does not arise, even where they have deducted, because there is no actual deduction that is made from the employer's salary, and deductions are only a notional accounting concept. So the employer cannot be held liable for those contributions. That is the argument that was advanced by the Post Office, for instance, in the matter between it and the fund. And the High Court upheld that contention in favor of the employer, but the matter went to the to the FSCA, which I will deal with briefly in my later slides. So as I say, in addition to paying contributions, there's a duty on the fund or the principal officer to make a reporting, to meet obligations of reporting in circumstances where contributions have not been received by the fund from the employer. It's either it's the principal officer or it's the monitoring person who has been appointed for such a purpose. And that reporting is dealt with in our conduct standard, which I think our colleagues who will deal at length with the conduct standard will canvass that in broad strokes, or perhaps at length than I can do in this particular presentation. So the issue that has been a vexed question and a thorn in the flesh of pension funds is the question of arrear contributions, which are occasioned by a lot of reasons, for instance. And one of the reasons relevant to the delegates here present, which I have identified, is the competitive nature of umbrella funds, in terms of which employees will hop from one fund to another while they remain in the employ of a particular employer, which invariably results in the employer falling behind on contributions where members change their membership without terminating their employment. So matters came to a head, I think, in this matter, and some of the funds, I'm not aware if all, but mostly funds would have a provision in their rules in terms of which they will prohibit members from terminating their membership during the subsistence of their employment with the current employer, and as such prevent members from leaving the fund, which as a result will have impact on arrear contributions or lack of them. So matters came to a head, I think, in the matter of the Municipal Employees Pension Fund versus SAMU National Provident Fund, as it then was, where the employees of a local municipality in the Transkei and Ndabanguli municipality had terminated their membership in the fund from SAMU to MEPF, but had not terminated their employment with the Ndabanguli municipality. So naturally, the employer diverted its contributions. Instead of paying to SAMU, it paid to MEPF. And MEPF, SAMU took the matter to court, claiming arrear contributions from the employer and claiming a refund of those contributions from the MEPF. So the contention that was put before court in that matter was that, by MEPF at least, was that that rule does not prevent members terminating membership from one fund in favor of another. What it in fact does, it simply prevents members from terminating their membership with the view to accessing their withdrawal benefits. That is the only reason that rule is there, which I presume most of your funds would have, if I'm correct about that. So the High Court agreed in Ndabanguli municipality with the contention put forward by MEPF, whereas the same court in another division, obviously, had found in favor of SAMU, I think, in the matter of Mzimkhulu versus SAMU National Provident Fund. So the matter went to the to the SCA, where the SCA said the contention put forward by SAMU is the correct interpretation of that rule. And it is for a specific purpose, especially in the umbrella funds, where there's a lot of traffic, there's a lot of movement from one fund to another by members. And if it were to be allowed, the rule to be interpreted in the manner as contended for by the MEPF, there will be chaos in the administration of pension funds. It will just be not manageable. So that interpretation was correct, said the court. And MEPF obviously tried to bang on the Constitution, the right to freedom of association of the members. And the court said the right to freedom of association of members is not unlimited. And to the extent that it may be infringed, there's a specific purpose for which it must be limited. And as a matter of fact, members' right to freedom of association starts and ends during the induction of members into the fund. That's where your best chance of choosing your fund is once you've chosen your fund, then you are locked. You cannot move while still in the employment of the same employer. You cannot move across. So your best chance is at the very beginning, which then avoids the issue of arrear contributions arising as a result of the employees zigzagging from one fund to another. So having said that about arrear contributions, it is the provision of the PFA at section 13A7 that where there is a late payment of contributions as required by the Act, it attracts interest on those contributions that are not paid. And the date of that interest is calculated at the lapse of the 7-day period, by which time the contributions ought to have been payable. Then the next day is when you begin to compute your interest. And I'm aware, colleagues, that this is a matter of contention between industry and the FSCA, but I would like to leave it at that until representations are made for a position contrary to what the FSCA in its communication has put forward. So that is basically the scheme of contributions in under normal circumstances. But I wish to turn to employers experiencing financial difficulty as a precursor to the business rescue aspect of this presentation. And I wish to distinguish it by referring you to the case of the same case that I've referred to you above, which is the Post Office Retirement Fund versus the Post Office of South Africa. And what distinguishes this case is that the Post of South Africa, the Postal Services of South Africa was not under business rescue at the time. So the principles that the court had applied there are distinguishable from the principles that apply in respect of a business or an employer that is under business rescue. So what had happened is, as you know, the Post Office of South Africa was experiencing financial difficulty. And I'm using the words financial difficulty advisedly as opposed to financial distress, because that is a defined term in the Companies Act. So as I have alluded earlier, what the Post Office had done, had decided to alternate between creditors. This month they would pay the pension fund, the next month they would pay the medical aid, and then they will skip and do that kind of rotation. And the fund took them to court, having persuaded them to pay their contributions for the longest time. And the court said, no, the Post Office of South Africa is correct in that the liability of an employer to a pension fund is unenforceable in circumstances where the employer is broke, basically, where there is no money to discharge the liability. It cannot be enforced against the employer. And I think the fund had contended for what is called supervening impossibility, which is a construct of the contract law, which says following the conclusion of an agreement, if it becomes impossible for you to discharge your liability, you may raise that as a defense. So the court upheld that, but the matter went to the Supreme Court of Appeal, which disagreed with the lower court and said the employer does not have the right to pick and choose which creditor to pay during which month. Otherwise, that would amount to self-help or taking the law into the employer's hands, some form of vigilantism. It cannot be countenanced. And further, the defense of supervening impossibility is not available to an employer where that impossibility is self-inflicted by the bad administration of the employer and his financial affairs. So the liability attaches. But what I think is significant about this decision is the entrenchment of contribution, arrear contributions, as a means by which constitutional rights to social security are vindicated. And also the court went further to say it is an unfair labor practice, as a matter of fact, because the right to fair labor practices is enshrined in the Constitution, and all of those rights are affected when an employer does not pay contributions to the fund. However, where an employer does not avail itself to the self-help measures that the Post Office had at its disposal, the Pension Funds Act is not without solution. Under Section 13A4 of that Act, in terms of which the fund or the board may take a resolution to reduce contributions or to suspend contributions altogether. But that only happens to the extent that the resolution to so reduce the contributions does not affect any liability that has arisen prior to the resolution being taken. So in other words, if by way of an example, you're a fund and you are in arrears from, say, October, November, December of the preceding year, and then you take a resolution in January to suspend or terminate contributions or reduce contributions, sorry. What Section 13.4a says is that you may not affect the contributions that were already in arrears because that liability was already attaching to the employer before the amendment was made. So coming to the issue of business rescue for companies in financial distress, and as I have said, it is distinguishable from just financial strain, which may not meet the definition of financial distress as contemplated by the Companies Act. So it is a mechanism to which employers who are in financial distress can avail themselves just to give themselves a breathing space, to put at bay or in abeyance the claims of their creditors. So if I may just read it just for accuracy to give you an idea of what business rescue entails. Means proceedings to facilitate the rehabilitation of a company that is financially distressed by providing for temporary supervision of the company and their management of its affairs, business and property, a temporary moratorium on the rights of the claimants against the company in respect of property in its possession. And then it provides for the implementation of a business rescue plan that must be developed by the business rescue practitioner. So what that means in simple words, colleagues, is that an application can be made to court pursuant to a resolution of the board, in terms of which the company will put under business rescue. That will allow it breathing space by keeping in abeyance claimants' rights against that company. That's what it basically means. So you develop a business rescue plan, which must be adopted by the affected persons of that company, including creditors and shareholders. And colleagues, I will not hold myself out as a insolvency fundi. My interaction is limited in this subject to the extent that it has implications for retirement funds. So as I said, that financial distress is not a throwaway term. It is specifically defined in the Companies Act, and it has a specific meaning, which is not the same thing as just having financial trouble, and you do not fit the four corners of the definition. And this is what the Companies Act says to define it. Financial distress in reference to a particular company at any time means that it appears to be reasonably unlikely that the company will be able to pay all its debts as they become due and payable within the immediately ensuing 6 months. Or it appears to be reasonably likely that the company will become insolvent within the ensuing 6 months. But the point of this is not to nurse, dead bodies back to life, as it were. It is for companies that have a realistic chance of survival if the business plan is sound and it is adopted. It is not a means by which you can avoid being liquidated. For instance, there must be good grounds for believing that this company can be resuscitated, and as a result, you keep in abeyance the rights of claimants against that company. So what are the legal implications of a company which has been put under business rescue? The first point is that there can be no legal proceedings that can be brought against this company during the business rescue process. And by legal proceedings, it is envisaged that any proceedings of a legal nature before any forum, which means arbitrations, for instance, private arbitrations or public arbitrations, and complaints to the adjudicator, for instance, can at moratorium once a company is under business rescue, and any action or any application that had been brought successfully against the company cannot be executed. Any order cannot be executed against the company whilst the business rescue is in force. Obviously, there are exceptions to the rule, and there are requirements in terms of which that can be done. As an example, the business practitioner, a business rescue practitioner, can give consent to the company being sued, and which consent must not be unreasonably withheld, given the purpose for which the business rescue was executed in the first place. And secondly, you can apply to court to lift the moratorium on legal proceedings. So you must be careful when you do that, because in most instances, interested parties, for instance, like unions, would bring applications against a company for rights that flow from the employment contract, and they would mistakenly assume that the labor court has jurisdiction to hear that. And the Labour Court has in fact declined to accept jurisdiction to lift the moratorium, though it has agreed to hear the substantive application where a moratorium has been lifted by the High Court. And the reason for that is that the High Court, the Companies Act specifically designates the High Court as the correct forum which has jurisdiction to uplift the moratorium. So, bringing it to what is relevant to you as pension fund practitioners, what are the legal implications of a business rescue? The first thing that the Companies Act says is that there is no impact on the employees' contracts of employment upon business rescue being approved or being granted, the company being granted to institute business rescue proceedings. And the employees will remain employed on the same term conditions such as they prevailed before business rescue proceedings were instituted. That's the first point. And the business rescue practitioner may not terminate or suspend any provision of the employment contract during business rescue. So there are two things that I want you to bear in mind and think of very carefully in relation to remuneration of employees during business rescue and before. The Companies Act says that any remuneration that was payable to the employees during the business rescue proceedings, in other words, when the business rescue proceedings have commenced, but has not been paid, that remuneration will be deemed as post-commencement finance and may be payable to the employees later if the business rescue proceedings are to be superseded by liquidation proceedings, for instance. And in respect of that, employees will become preferred creditors, which will rank just below secured creditors. There will be preferred unsecured creditors in respect of any remuneration, and any money that flows from the employment contract to which is owed to the employee by the employer under business rescue. So the same is true, for instance, for any remuneration that has become due before the proceedings were instituted, save for the fact that it will not be regarded as post-commencement finance, but the employee will still be a preferring creditor for purposes of liquidation if the company should go into liquidation, or if, for that matter, it is back to financial health, and the employer is able to discharge its liabilities as against the employees. So, what are the implications for pension fund with respect to business rescue? So the Act says any amount of money that is owed to a pension fund before the business rescue proceedings, and I put an emphasis on before, that is arrear contributions in our language, that in respect of that money, the fund will be an unsecured creditor. In other words, it will benefit from the free residue of the proceeds of the company once it goes into liquidation, and that makes it makes the fund to rank lower than the preferring creditor, which is the employee. Now the question becomes, what happens to ongoing contributions during business rescue proceedings? Is there a moratorium on business rescue proceedings, on pension fund contributions during business rescue proceedings? And colleagues, I must admit, I have not canvassed the views of my colleagues on this point, and just to take their temperature as to what is the position. And as such, I will not delve into that in this presentation, save only to just make a comment on what I've read the commentators say and use as authority for the proposition that contributions must, as a matter of fact, continue to be paid, notwithstanding the business rescue proceedings. And they cite the case of Metal Industries Provident Fund versus TK Office Supplies, and another, where the fund had brought an application to court demanding arrear contributions which had accrued before business rescue proceedings. And it had cited the fund as the first respondent, and it had cited the employer, sorry, the director of the employer as the second respondent. So what happened there is the court granted the application that was later brought by the fund to separate the application as against the first and second respondent, and postponed the application between the fund and the employer. And the reason cited for that was that the employer must first finish its business rescue proceedings before this application can be heard. And the court granted that and awarded costs to the employer. So the decision was made only as against the director. And the reasons that were cited by the court was that the director was sued under a different subsection of section 13A, which is sub 8, which imputes personal liability on the director in circumstances where contributions are not paid. And that was in respect of arrear contributions, but not ongoing contributions. So that is a point that I want you to think about as you wrestle with the question as to whether or not there is a moratorium on current contributions during business rescue proceedings. And it is true that the director had raised the issue of the the business rescue proceedings having no impact on him because he was acting under the direction of the business rescue practitioner, and such a contention was rejected by the court. So in the ultimate analysis, the court made a finding, made a ruling, an order as against the director personally. So having said that, it seems to me that that authority or that decision is not good authority for the proposition of whether or not contributions, the liability for contributions attaches to a company during business rescue proceedings. So that is basically that about business rescue proceedings. But I thought perhaps just for purposes of completeness, I would draw a contrast between companies under the Companies Act who are in financial distress and municipalities, to the extent that some of your participating employers may be municipalities, for instance. And the distinctive features of this category of participating employer is that the financial difficulty of the employer in this instance is dealt with by the Municipal Finance Management Act, read with section 139(5) of the Constitution. We all know about municipalities being put under administration and that sort of thing. This is where it emanates from. But what it does is that it gives two scenarios which may find application to a municipality under financial difficulty. And I stress the distinction because the Municipal Finance Management Act actually uses the word financial crisis, not financial distress. So it contemplates a situation in terms of which the employer, there may be an intervention for a financial recovery plan, either depending on the depth of the crisis, either as a discretion of the provincial government, or a mandatory intervention where the situation is so dire, such as to warrant an intervention. But what is distinguishable between this scenario and the Companies Act is that it does not affect or does not impose any moratorium on legal proceedings against a municipality. So a creditor, like a pension fund, may very well bring an application for payment of arrear contributions, even in circumstances where there's a business rescue plan, for instance, that is aimed at bringing the municipality back to financial health, and the rights of creditors are not suspended, and the rights of employees are not affected, save obviously to the extent that the employer, which is the municipality, may specifically apply to court to keep its creditors at bay, and that application may be granted on good cause shown, provided that it does not exceed a period of 3 months at any given time. In other words, you'll have that reprieve only for a period of 3 months, and if you're still under supervision, then you may apply if the necessity arises. But there is no moratorium on creditors' rights, such as is the case, for instance, with companies. So basically, that is it, colleagues. I hope I have not. I must apologize for the slides, as I had indicated earlier. But that is it, Chair, and over to you with thanks.
Thank you so much, Mr. Mbono, for such an insightful presentation. I mean, you covered the legislative landscape very well, even though I have to say so myself. We have a couple of minutes before our break, and I think we can take one question just before we break. I see there are no comments on our chat box. Ladies and gentlemen, please feel free to ask questions if you have a question. There's a hand. Yeah. There's a hand up. We have one hand up. Mr. Daliwe. Marilyn, please. Yeah, can you please help me unmute Takalani, yes.
I have unmuted everyone, so I mean the people that have their hands up, so they can make their comment.
Okay, I'll start with Haneli, please.
Good morning, thank you. I posted one of my questions on the comment box, but maybe in brief. And thanks for this very informative discussion. I litigate 13A issues frequently and see some of these issues arise repeatedly. I have a few questions that jump from this presenter's presentation. The first is this: honorary contributions due by employers in business rescue and even litigation. If you're in the position of the fund, it seems to me that the shortcut or the clear, cost-effective option for a pension fund is simply to sue the directors under the personal liability provisions of the Pension Funds Act, and not to bother with trying to create new law and, in DC funds cases, use members' money to figure out if the employer entity is still liable. There's one other Western Cape High Court case in engineering industries that said the same thing as TK Office Supplies. Is that the position as the FSCA has it as well? If a fund can simply go for personal liability against the directors in cases of business rescue or financial distress? Thank you.
Thank you so much, Haneli.
Can I take that,
Tando?
Julia?
Oh, please.
All right. So thanks for the question, Haneli. This is, in my view, what you first have to distinguish. You have to distinguish between contributions arrears that arose before the business rescue proceedings, and arrears that arose during the business rescue proceedings. And with the first scenario, I would agree with you that you may bring an application to court because that liability of the employer is imputed on the director during the time that these arrears were incurred. But with the second option, it depends on what your view is of whether or not these arrears, the contributions there's a moratorium on the contributions, for instance, or not. Because if the employer cannot be held liable for contributions during business rescue, remember that the liability of the director is vicarious to that of the employer. So how do you sue somebody that in the circumstances of a business rescue, you would not have complied with his duties at any rate, even if he tried? How do you found that a cause of action against the person who is vicariously liable when the main person, which is the employer, may not be held liable during those proceedings? I mean, during the rescue proceedings. And of course, it is contingent upon how you answer the question about whether or not that moratorium is in force during a business rescue. Thank you.
Thank you so much, Tando. We can get the question from Deliwe Kupe. Yeah, please unmute Deliwe.
From UPC.
Deliwe, please unmute on your side.
Sorry?
We can hear you now.
Okay. I'm Moses Tulo from UPC. My question is around firstly, delayed payment to interest The question is, if it accrues to the fund, does it relate to accruing for the member itself, or it's just for the fund for use? Now, the other thing is about exemption that is sought by the companies when it comes to the provident funds.
I think I lost the first question. Can you please repeat it? You said, does
I
it
had the first
relate or
question,
accrue
it's
to
the
the
second
member?
question, really.
Yes?
That thing says, hold on, category. Okay, that.
Okay. Now, I want to know what happens of those if a company is exempted from paying the pension fund contribution, and who pays the area? So, what happens in that regard? And lastly, I just want to find out if we go to the SAA and the municipal cases, do those people get paid, or it is just an idea that you had from the case law or something? Is there anything from the FSCA that shows what happens in that regard, other than looking to the case law? Thank you.
Thank you so
Thank
much,
you,
Tando.
Julia,
would
if
you-
I may.
Yeah, please.
So the first question is the easy part, that the Act is very clear that interest is investment income for the fund. So it accrues to the fund. Remember, the fund is the creditor for arrear contributions. So that's the easy part. The second question is about what happens to the arrears if the employer is exempted from paying contributions. And I assume that by exemption, the colleague is referring to the moratorium that applies during business rescue proceedings. And I tried to explain to the meeting that I cannot commit to that question of whether or not, in fact, the moratorium applies to pension fund contributions. And it's a view that I have to converse with my colleagues, and I wouldn't want to bind the FSA on what, in my view, is a controversial issue, because others say because there is the sanctity of the employment contract remains during business rescue proceedings, and therefore the business rescue practitioner may not suspend or amend any provision or any term of that employment contract. Therefore, it follows that pension fund contributions are payable. But there is a contrary view, which I would like to not answer at this forum at this stage, if the colleague allows me. I didn't hear the last question.
The last question relates to exemptions from what happens to those employers that have exemptions from paying contributions, if I'm not mistaken.
I think that's the question that I was addressing, and I had assumed that by exemption he means the moratorium on
Okay.
on rights of claim by pension funds.
All right. Thank you, Tando. We'll take one last question from Marilyn, and then we'll just break for maybe 5 or 10 minutes, and then the rest of the questions, Mr. Gube will deal with them during our Q&A. Marilyn, please. Yeah, can you please help unmute Marilyn?
Marilyn, can you please unmute?
Okay, I think can you hear me now?
Yes.
Okay, great. There are times when the employer, when under financial difficulties, from the employer side and also from the employee side. Obviously, that results in the liability from both parties. Then there are times where the employer stops, but he continues to deduct the employee's contribution and doesn't pay it over. Then there are times where the employer cannot pay the contribution, so he stops deducting from the members for a period and pays the member out contribution as part of the salary that should have been deducted from the member. Now, in that instance, the contribution is certainly not being paid to the fund, but the member is receiving it in cash as part of his contributions. And only after a couple of months or so, when we've managed to get some agreement with the employer or have addressed the issue with the employer says, well, I can't go back and deduct this money again from the members. So from here, what has been the practice and what has the FSCA or what is the legal requirement at that stage where the members physically receive the contributions that should have otherwise been paid to the fund?
Can I take a step, Julia?
All right, thank you, Tando.
All right, let's start with the legal, or maybe end with the legal response to it. First of all, as I said, Section 13A is very clear about the obligation to deduct. It is not an optional, thing that the employer can avail itself. It must deduct as a matter of law, and the FST has dealt with the obligation, the persisting obligation to pay over contributions, even in circumstances where you have not deducted as an employer. And I think this is what was dealt with in the post office case, where the employer said, this deduction, in fact, is a fiction of accounting. It is a notional deduction. It doesn't actually happen. We don't deduct people's monies because we don't have money in the first place. So we cannot be held liable for something that we have not deducted. And the court rejected that and said, that's vigilantism. We don't do that. And once you don't deduct and you don't pay, you are in effect prejudicing the members' rights, even to social security at the level of the Constitution. So what happens when the member has been reimbursed by the employer in circumstances where, in fact, that money ought to have been remitted to the member, to the fund? So I think 37D is very clear under the permissible deductions that may be made from a member's benefit, that any contribution that has not been received by the fund can be deducted from the member's benefit only in circumstances where it was not the fault of the member, but the employer that did not remit the contributions. May the member be excused from that deduction. So in this instance, the member did get something at the expense of the fund. So that portion is permissibly deductible from the member's benefit. Thanks.
Thank you very much. Thank you.
Thank you so much, Tando. Thank you so much, Marion, for that question. Ladies and gentlemen, we are going to break now. Is 10:09, technically 10:10. So we'll break for 10 minutes and we'll be back at 10:20. Thank you.
Julia, are you there?
Yes, I'm here.
Okay, I'm just going to share my screen already, so before the people come back in, so that I don't waste time when they come back.
Okay, all right.
Okay, then.
Thank you. Welcome.
Okay.
Julia. Julia. Julia.
Yes.
Yeah.
Yes,
Tell me,
Ezekiel.
do you have our presentation? Are you going to share the presentation? Our presentation.
No, Ezekiel, we don't have your presentation. Do you need us to share it or?
Yeah, please. And we just want to, okay, we can change it and we can send it to you guys or
Okay, please do that.
all right.
Welcome back, ladies and gentlemen. Yeah, are you able to hear me?
Yes, I can hear you, Julia.
Okay, according to my timepiece, it's 10:20. Before we start, thank you so much. Before we start our second session for the day, I just want to remind you that the Conduct Standard 1 of 2022 will be covered in part 2 of the webinar, and we'll communicate the dates in due course. Ladies and gentlemen, we are now moving to the second session for the day, and our speaker is Ms. Muvhango Lukhaimane, who is the Pension Funds Adjudicator and has since been the Pension Funds Adjudicator since 2013. I think many of you are quite familiar. She'll be taking us through prescription in relation to retirement funds and arrear contributions. Thank you, and over to you, Ms. Lukhaimane.
Thank you very much. I'm struggling to share my screen, so it would have worked better if people could see the presentation. But if we are struggling to share the screen, then I'll just proceed. I am not sure what, I mean, I even have the technician here. You see, it gives me that and it doesn't give us an option to upload our presentation.
Are you able to send it through to us?
The presentation?
Yes, and maybe we can move to the next speaker if you
No,
still want to share.
otherwise then my day is finished. If I don't do now, already I've backed up everything. I can email it to you and I'll be talking in the meantime. The presentation will find us moving along.
Okay.
Let me do that rather. My apologies for that. Let me just say caveats. So this the presentation is gonna come through with nothing on it. So I've just sent it to you.
All right.
Okay, thank you very much for the invite. I think for those of you that follow the outcomes from the Financial Services Tribunal, you would have noted that whatever leeway we seemed to think we had in terms of just dealing with prescription and outstanding contributions, we don't have. Therefore, we are very strict also in the application of prescription, because we don't want a situation where members go out with determinations that are not worth the paper they are written on. If I just look at our office statistics, just to give you a background of the impact of this in terms of the caseload. Last year we would have had about 80, last year meaning the period to the end of March this year, we would have had about 83% of our complaints cover Section 13A compliance and withdrawal benefits. What I can tell you is that the bulk of those Section 13A compliance matters and withdrawal benefit matters have got to do with instances where employers have not paid all contributions, and unfortunately now upwards of 50% of those determinations, as we grant them, the member is only able to get partial redress because the other period would have prescribed. So the impact of not following up on outstanding contributions that prescription has is huge on members. In the period April, May, June of this year, we started keeping our own statistics on if we issue an order sounding in money, excluding late payment interest. Of the 713 matters where we managed to issue orders sounding in money, we issued orders for amounts totaling 20 million rand. And that then represents what the member could recover. And in most of these instances, the bulk of the period would have already prescribed. So members have lost, in the instances where we were able to give orders sounding in money, members have lost more than 20 million rands because of prescription. If I can just go into, as I was saying, I will actually make the presentation available because it is in so much detail that some of you can also use it for your own internal purposes. So the FSCA can make it available where they will make available their other presentations. So the law for us would say we have prescription because if I owe you money, I'm supposed also to have access to the records that say I owe you money. So in order to protect debtors and creditors in terms of claims against each other, you cannot have a claim that just goes on and on and on, because if the debtor wants to defend themselves, maybe now, which is something that funds raise a lot. We have lost records, we have changed systems. So the sooner the complainants or the sooner the members claim what is outstanding for them, the better. So really prescription, the court's approach is In terms of the Prescription Act, they approach it as we need to be able to give people that owe each other, whatever it is that they owe each other, we need to offer them certainty, legal certainty. Therefore, that is why there's prescription. You'll see in the determinations and as we hand them down that we try to err on the side of the member. So we will go back to the member and ask additional questions, really trying to see how much of the period that is prescribed can we bring in to the fold. So while we understand that the law says contributions have prescribed and that we still try because of all sorts of things, from levels of financial literacy to the amount of time that funds communicate with their members as to this is your benefit statement, your employer owes money. We keep that all in mind. That's why we bend over backwards to try and see which period can we accommodate. I think I am already on slide number 7. Am I able to manipulate the slides myself, or are you gonna do it on my behalf?
Muvhango, I'll do it on your behalf.
That is fine. Thank you very much. And just so I don't disturb people that want to have a look at the slides, and I'll then sort of mute my camera. Okay. You can skip that slide. Really, it's for people will then familiarize themselves with that when they have a look at it. But in terms of, if you look at what is said on slide 8, it's really for me to highlight to you that if you have a principal debt that prescribed, the subsidiary debt will also that arose from that will also prescribed. If we look at the next slide talking about the periods of prescription, one of the things that helps complainants is where they approach our office as soon as possible, because then whatever it is that was owing to them will become judgment debt. Once we issue the order and it's an order of court, then at least their claim period will extend from that 3 years to 30 years for them to then enforce that judgment that they have. So it's critical that even for funds, it's critical that funds, if an employer has not paid for a certain period of time, once that time has been covered by an order that we would have granted, it's better if you come through and institute another claim so that you can have another judgment order that then buys you more time for you to enforce the debt that is outstanding. And of course, pension fund contributions, retirement fund contributions fall into 11D of the Prescription Act, which is the 3-year period that covers any other debt. Thank you. You can move on to the next slide. Now, when does prescription begin to run? As soon as the debt is due, which means as soon as you get a letter of demand and the debt is due. But when we try to extend a little bit when we get complainants is under 2 and 3. Where, for example, if the debtor willfully prevents the creditor from coming to know, maybe some complainants might go to their employers and say, may I have my payslip? May I have my payslip? And then they are not given that. That then prevents the person from knowing what they are, whether certain deductions are happening or not. Under Section 12.3, then you have the provision that a debt shall not be deemed to be due until the creditor has knowledge of the identity of the debtor and of the facts from which the debt arises. So usually this for us will come as in the form of members get knowledge from other people that might have resigned from the company and not being paid. And a member will be asked, when exactly did you find out? Some members will then give that information to say, when my fellow employees left, that's when I discovered that the employer was not paying. So we try, this is a factual inquiry on our part to say of the member, when did you become aware that the employer has not been paying contributions? This then makes it very critical for funds to provide members with benefit statements on time, and also to do that alert where your 30 days, 60 90 days notice to say that the employer has contributions outstanding. Unfortunately, what is happening now is that funds will generate letters automatically off of their systems when contributions have not been paid, but those only go to the employer. So you have a situation where the members remain in the dark as to whether contributions are owing on their behalf or not. And if you have had a look at the outcomes from the tribunals, the reconsideration matters that go there, you will note that whilst I can sit in this office and have more information as to what members know and do not know, for the tribunal, it's almost an absurdity for them to accept that a member did not have a payslip. They don't think that it's possible that a member could not have had a payslip, but we all know that happens. So that is why you will see that in our determinations, as we try to bring something into for purposes of those determinations being able to stand up to scrutiny at the FST or in court, where we will not be to defend those outcomes. We try and put into perspective a little bit of what members are likely to know and what they are not likely to know by exercising reasonable care. You can move to the next slide. And that slide just deals with the impediments that I thought are important for people in our spaces to know, and that I think, given that you are all running behind schedule, that you can go over for yourselves when you have a look. But the important ones you see, they'll arise as I talk to you in the presentation. So slide 11 and 12, you can just skip, and then we go to slide 13. That talks to interruption. When is prescription interrupted? If this one is the easiest, the first one, where there is an express or tacit acknowledgement of liability by the debtor. And usually here you'll find an employer that accepts and says, yes, I know I owe these contributions. I know I owe these contributions. I've entered into an acknowledgement of debt. And even if they have not entered into the acknowledgement of debt, they would usually say, I know I owe, just ask the fund to do the calculation and then I will pay. Which then brings me to something that is of concern, because whilst we will have your PSSPF funds, your transport sector, they will calculate for you how much is owed. But I can't even remember a single umbrella fund that has ever bothered to calculate how much is owed on behalf of an employee. Therefore, we have this situation where funds can assist you to say, now let's have a situation where, because you as a fund, you failed in the first place to collect these contributions. Now tell us how much this complainant is owed so that we can include that in the order and the complainant can go and enforce that with the sheriff. None. I mean, unless that was done on a day I was not signing determinations, I've never seen a single umbrella fund bother to even do the calculation, which means that you've got members sitting in umbrella funds where employers owe a lot of money. The complainants come to us, and at the point where we want to issue the order, we request and we say, can you please tell us how much this member is owed? And they just don't respond, and we can't sit with the matter open for forever because the fund is not responding. And then after a few months, the same fund starts saying, well, we actually decided to liquidate the participation of the employer, because that for them is the easier route than for them to actually try and recover the contributions, or even offer the complainant assistance when the complainant has tried to say, I'm trying on my own to go and claim, just tell the adjudicator how much I am owed, and then funds just don't bother with that. So that is one of the things that is of concern, and yeah. If the running of prescription is interrupted, then it will start to run afresh from the day on which the interruption takes place. I think that is clear. You can work that out for yourself, but it's always easier when the fund, usually the fund will only accept that we are holding a particular fund credit, but if the employer doesn't say anything about the outstanding contributions, then there's nothing that we can do if they have already prescribed. Can move to the next slide. Now, this is one of the key principles around prescription. No one can acknowledge a debt after prescription has run. So if a debt has already prescribed, the 3-year time period has passed, and the employer comes and says, oh, by the way, I actually acknowledge that I owe. That doesn't mean that that is legally enforceable. Yes, the employer might have said, I acknowledge that I owe this money, but we can't legally hold them to that because the acknowledgement came after the 3-year period had run. Next slide, please. Again, also prescription would be interrupted where service commences, summons, or whether the person lodges a complaint with us. However, and which is something that happens to most complainants, sometimes complainants will go to the wrong office, and then by the time they come to us, then the matter has prescribed because they didn't raise the issue with us with the correct structure from the beginning. The mere fact that they raise it elsewhere within the 3-year time period will not offer them any escape, because they should have come through to us. Here is where we will then plead with funds to say, instead of just saying to complainants, if you have a complaint about this and that, go to our office. I think also the messages that go out when there are outstanding contributions can also include that aspect to say, whilst the fund, if the fund is doing so, it can say, whilst the fund is trying to recover these contributions on your behalf, you can also approach the office of the adjudicator. We are available to tell you exactly when the employer stopped paying contributions or on your behalf, so that at least on more fronts you've got people trying as much as possible to recover what is outstanding on behalf of members. You can move on to the next slide. Okay, that one's, it's a read. I think I gave more information because it's sometimes it's a little bit of a difficult subject to get your head around. You can skip that slide and then people can read that on their own. In terms of time barring, I'm now on time. Okay, let's wait on this slide so that I can just explain it. Yes, there are employers that will come and raise the issue of prescription. And if a matter is sitting at court, for example, it will say something like a court cannot of its own say a matter has prescribed. The court will wait for the party who is invoking prescription to then invoke it as a special plea, or sometimes even as a defense if there were other issues in the merits that they needed to deal with. So, but for us, because our office is specifically precluded from dealing with matters that have prescribed, we are supposed to take notice of that from the beginning. Otherwise, then our orders cannot stand, and that is the slide that follows, slide 18, where then we invoke. So what the legislature then did was to say we have to deal with an issue of time barring, but in saying how we go about determining whether a matter is time barred for us or not, then the Act imported the provisions of the Prescription Act. When I say the Act, I just mean the Pension Funds Act. So the Pension Funds Act imported the provisions of prescription. So where a court needs someone to defend themselves with to raise prescription as a defense, for us, the Pension Funds Act did it the other way to say you are not allowed to deal with matters that have prescribed, and therefore we automatically then import the provisions of the Prescription Act for you to apply out of the blocks without anybody having said anything. If you don't, then of course on appeal or reconsideration, then it means our orders will be thrown out. So we are very, very strict in our application of prescription. And then so where do we then say the member must have known of the debt? And that's the next slide. So the biggest the one place where a member would learn that there is something amiss is communication from the fund. General communications, specific communication on 13A, annual benefit statements, salary advices. I have indicated just how difficult it is in certain environments for people to get their salary advices. So if funds have got alternative means of getting this information to say deductions are either not being made, because also for most members, for example, we would say, yes, the member was seeing deductions on their payslips. That's why they thought nothing was amiss, because the fund was not giving an annual benefit statement. So we would still say, yes, we can investigate beyond the 3-year time period. Also, members can learn of outstanding contributions from their contribution statements. Those that have access to online services, those that get SMS notifications with their contribution statements, they can learn from that. The important people then would be, the monitoring person. Is the monitoring person providing a report, and then also notification to affected members in terms of regulation? I think that is why it helps. I know that the FSCIs, I'm not sure to what extent they have started working on an implementation of this, where they would then indicate which employers owe contributions. That helps, because if the monitoring people, most funds will say to us, they have reported the outstanding contributions to the FSCA. So in most instances, the FSCA has got more data in terms of what is outstanding out there than we would have. Next slide, please. I think this is just a links. The matter of links is just one of the matters that on prescription assist in terms of saying, what would the courts look at in terms of whether or not a member had knowledge of the debt. And it's actually an interesting matter to go through on its facts, and also just to follow the legal argument. So you can do that in your own time. But really, this was an instance where a person was injured, but it was only when he received a particular report from a doctor years after the incident took place that he then had the knowledge as to the fact that I can institute a claim. So we give this example to you so that you can just see to what extent we also try and go, and you will see that up front in our paragraphs 5, when we do our analysis up front, you will see just to what extent we try to go in engaging with the member and also with the fund to try and see whether a longer period can be accommodated in terms of outstanding contributions, or whether we can only just go only to the 3-year period, to the date that the claim was instituted. So I'm not going to go through the links judgment, but what I give also in terms of the slides up to slide 22 is sufficient for those of you that wouldn't be interested in really knowing what the nitty-gritties of the law was and all of that. For our purposes also, if you have a look at the matter of Rousseff versus the Johannesburg Municipal Pension Fund, this was also in an instance where the complainants didn't immediately act on something, that just so you can see where do we get the issue of a claim being in continuing form, and that which has already been specific, that which has a specific cut-off date. So I also won't go through Rousseff to sort of save you time, but it deals with this if you can just stop on slide 27. Yeah, 27. It goes to this instance where what knowledge did you possess, and when did you have an understanding of the fact that because sometimes people might give you information on a piece of paper, but you don't really appreciate what that information means, because it requires someone else who is maybe an actuary or someone else with some other specialized knowledge to explain to you what it all means. I'm sure that some of you would have received complaints where complainants don't even understand how to read their own benefit statement. So you can imagine how then they discern whether there's something outstanding. Complainants will come and say, I thought the amount indicated as pensionable emoluments is my withdrawal benefit, and so we know what sort of complainants we have. So that information that also requires expertise for a person to be able to understand. We will then look at the reasonableness of when actually they acquired that knowledge. And this case of Rushdorf is also important in illustrating where in certain instances the obligation doesn't have a strict cut-off in terms of prescription, but has got a continuing obligation. On slide 31. That is also the matter of seeing where, just as towards the end of Rushdorf, I was explaining, this is where you also have the concept of a continuing wrong, which is still in the course of being committed. So there will be certain instances where we are able to go back longer because maybe something comes out of the rules as they are set, and we cannot, by the nature of the claim, we cannot say it is located wholly in a single past action, but you have an instance where, for example, usually when you are dealing with disability claims, it has that element of a continuing obligation, of a continuing wrong. And the issue of Makate also illustrates that, so I will not go into that, but then we can go and stop on the last slide, which is slide 34, where we then have to say, this I can read out to all of you just so I can explain the principle here. It is indeed so that there is a statutory obligation to pay interest on outstanding amounts. It was also acknowledged by the respondents in an acknowledgement of debt. However, the fact that there is a statutory obligation to do so does not mean that it can never be prescribed. As set out above, the payment of such interest is a debt, and this will be prescribed after a period of 3 years. So sometimes you find that funds will come and want to claim late payment interest that has prescribed some time before. So that also cannot be, we cannot entertain. So it's also up to you as funds. If you tend to move on late payment interest that is outstanding, you should know that that is also capable of prescription. And that is where I stop. I think from our office, our biggest message is really that the sooner everybody has knowledge of what is outstanding on their behalf, the sooner they can invoke the law to assist them to claim. Otherwise, we are really now, we want to do this for this year and the following year and just illustrate just how much members are losing out because action was not taken on time. Thank you very much.
Thank you so much, Ms. Lukhaimane, for such an informative presentation and for sharing statistical information on complaints in relation to area contributions. We'll now allow for questions on your presentation or even comments from the audience. If there are any questions, Mr. Coupe? Nandi, can you please unmute the speakers?
We have allowed their mic so they can just unmute on their side.
Yes, I think we will shift our question to the questions and answer session. We do not have specific question to the current speaker.
Okay.
Thank
you so much, Mr. Coupe. Thank you. Wanda Mashiko?
Thank you. Mine is a comment regarding the description of our cases with regards when it comes to members from the point they knew of their debt. I'm a bit concerned that the Act has this prescription jurisdiction on pension fund adjudicator, where it is the Muvhango is indicated, they are not allowed in the first place to entertain such claims if they have prescribed. I was hoping that prescription would be entertained by the adjudicator only as a defense if raised by the respondent, because if we want to put the members at the center of the law and at the center of our operations, we would entertain any as they come and only wait for the respondent to probably raise prescription as a defense, because knowing the existence of the debt in the first place is a result of being informed. For a member to know that there is a debt in the first place, they have to be informed. Certain parties around them have to do their job, like the employer, like the fund. They have to relay that information to the member first. So now, if they only get to know of it too late, prejudice is still visited on the member. So I was hoping that maybe the Act would loosen this screw and allow the adjudicator to entertain or even those cases that may have, by today's description, prescribed, and probably entertain it as only as a defense. Because when I look at it as it is now, it means they'll lose out on what they would have claimed, as much as they would lose out on unclaimed benefits. It's like we would say now, your unclaimed benefits are more than 3 years old, you lose them. It's almost the same thing. Thank you.
I'm not
Thank
sure
you,
if
Mr.
you want
Mashiko.
me to respond as we go along or take a few questions if there are some other questions.
You can take this question, so we'll just take the questions as we go.
Okay. Unfortunately, because we do not have inherent jurisdiction that a court has, we cannot wait for prescription to be raised as a defense by the respondent. That's why I illustrated that only in court can that happen, and we don't have inherent jurisdiction. The member, I think, is given, if we work from when a member is reasonably supposed to have known, the issue then becomes, if they knew, did they know then of the existence of our office to come and complain? That is why I said it's very important that people are then told that they can complain, because if they just know, many members will come and say, yes, I was aware that the employer was not paying, but I kept asking the employer, I kept asking the fund. They never thought of lodging a complaint. So they've got to be told that next step to say, you can you can lodge a complaint. And unfortunately, there are funds that would even tell us when we forward them a complaint to say, there is a complaint, please respond to the complaint. The fund will say to us, this claim has prescribed. The fund itself, the one that was responsible for getting the contribution, will say, but what are you busy doing? The claim has prescribed. So, yeah.
Thank you, Ms. Lukhaimane. Are there any other questions? Mr. Mashiko, are you happy with the response?
I know that we have debates with Tando and Zarina on the issue of prescription, and I am not sure. I know we are escalating these issues to National Treasury because for us also we can see the harm and the prejudice on behalf of the member. But as the legislation stands now, our hands are tied. But one of the reasons why we are collating all this data now is so that we also don't talk to the policymakers, with nothing. We've got to have data to substantiate what we are talking about in terms of the prejudice to the member. That is why we have started doing that.
Happy with the response.
Thank you. Thank you so much, Mr. Mashiko. Are there any other questions? I'm not sure if Ms. Lukhaimane, you'll be part of the Q&A session. Are you coming back for the Q&A session?
It's fine. I will sort of
Okay. There's
around.
Okay, there's a comment from Deliwe Kube. Yes, Mr. Kube.
Unmute.
Good morning, ma'am.
Morning.
Yes. I just want to understand it. Is the bulking of funds allow countries and administrators?
I think you are going to have to repeat it for me, Julia. I couldn't get there.
Something like this design. My question is the bulking of funds by the administrator is a policy or it is just designed by the administrator themselves?
I cannot hear.
Yeah, Mr. Kupe, I'm also struggling to hear you. I can hear
Maybe
you're talking
someone
about
else that can
administrators.
hear that could hear the question could.
My question is, ma'am, I just want to understand whether the bulking of funds by some of the administrators is a policy or it's just something that is designed by the administrator themselves.
The bulking of funds.
Yes, it's what I'm asking. Because there are some other administrators who are bulking funds, whereas now, at the end of the day, we have some secret office around that.
I don't understand the question.
Hello.
Yes,
Hello,
the sound is better now.
Hello, Mrs. Muvhango.
Yes, now I can hear you.
I think maybe if I can try to simplify the question by my colleague here. He's basically asking a question on bulking, this thing that we call bulking.
Yes. What is the question on bulking?
Where administrators. Yes, it's a practice that is exercised by fund administrators where they take huge sums of money Sometimes they take them from a council fund, sometimes they take them from liquidated funds, and then place them on investments in bulk.
Yes. But
So,
isn't it that my
the
understanding?
question,
Mm.
can I come
Yes.
to the question?
Yes.
The question is whether is that lawful in this country, or the administrators are simply siphoning secret profits out of available funds in their reserves.
I mean, my thought immediately would be if a fund comes and complains to say, well, we don't think that our investment returns, I mean, that would be the nature of the complaint that would have to be laid to say, we don't think that our investment returns have been properly allocated to us. I don't think that in principle, when there was a fight with bulking, I don't think that the issue was around the fact that you cannot pool your monies and then invest. I think that the situation was around what then happened with the investment returns. The investment returns were not being properly allocated to where they needed to go. It was actually the administrators that were almost scheming of the investment returns in terms of allocating, instead of allocating them properly to where the funds that were invested originated from. So I doubt that. Well, that would be for the regulator to confirm, but I doubt that funds are continuing to do what led to that whole crisis with bulking, because also you've got a situation where you've got funds running member accounts, all sorts of things. So I think it's a little bit more difficult to do the kind of thing that we saw with that bulking crisis. But I may be wrong. I've yet to see a complaint since then. I haven't seen anything. Well, there are administrators and funds in here. They can speak for themselves.
Yeah, maybe if just to expand on the topic, my colleague would like to give some examples.
Julia.
Yes.
Good day, Mrs. Muvhango. My name is Thomas Malokotsa from UBC, from Unpaid Benefits Campaign. I think what my colleagues were elaborating about this bulking of funds, it's as good as administrators not looking into the beneficiary forms. It's like the Board of Trustees who have taken their own discretion of decisions without the consultation of the member himself. Now, I'm just making an example about that. Now, coming to the bulking of funds, it's as good as if you go to section 13 that you are familiar about, with regard to contributions that by law are needed to go into the fund, but then instead of together, what they do is they simply take the money, the member contributions, all members' contributions, and they park that money in order for them to yield profit, secret profit for themselves. And ultimately, at the end of the day, there isn't any penalty that is imposed to them. So now, this is where we are asking these such questions with regard to that. That is the PFA or the regulator. Are they aware of the bulking of funds by the administrators who are yielding secret profits for themselves? That's the question that we're asking.
Yeah.
That
well, we are We are
Yes.
definitely not aware from our office. We have not had a complaint of that nature. And I mean, in my interaction also with the regulator over the period of time since the big issue with the bulking happened, and that I haven't heard of the issue arising. But the regulator can speak for themselves when I am done. I think for us, should we get a complaint of that nature, it then falls to us to then go and investigate, look at the evidence that gets put in front of us, and to be able to sustain whatever judgment we issue has to be evidence-based against what the law prescribes for administrators and funds to do. So in short, we haven't had a complaint, and should such a complaint come to our office, it will depend on the evidence that we get in order to issue a solid judgment in terms of that. But the regulator, someone from the FSCA, can respond on behalf of the regulator.
Okay, thank you so much, Ms. Lukhaimane, and thank you, Mr. Kupe. We'll talk about the bulking later on in the Q&A session. I'm just looking at the time.
That is fine.
Our colleague of mine, our colleague Debo Khoramushu, will also take us through his experience of that, and also just comment on the questions that were posed by Mr. Kupe. Thank you so much, Ms. Lukhaimane, for your time, and we hope that you'll stay for the Q&A session.
I shall. Thank you very much.
All right. Thank you. Ladies and gentlemen, in the interest of time, we'll move, and our third speaker is Mr. Johan van Vollenhoven, who is a specialist analyst within the Reviews and Authorization Department at the FSCA. He will be speaking on the requirements of registration and deregistration of participating employers, and will also touch on the suspension and reduction of contributions, which is obviously linked to Section 13A. Mr. van Vollenhoven, Johan?
Hi, Julia. Oh, yeah, it's van Vollenhoven, but that's one that's very difficult.
Always,
surname to pronounce, so no worries about that. So, good morning, colleagues and delegates. Like Julia said, I'll just do a presentation on registration of special rules and deregistration of participating employers. I just want to get my slides on. Just tell me when you can see my screen. Julia?
Yes, I can. Thank you.
Can you see my screen?
Yes, I can.
Is it full slides?
No, I can see the slides on. There's a comment that just press F5. There's a comment.
Yes.
Earlier on. Just put it on presentation mode. Yeah.
There it is. Okay, wonderful. Thank you, Julia. Thank you. Morning, everybody. Yeah, I'm in the Reviews and Authorizations Department, and I'll be just going through.
Sorry, Johan, you're not on presentation mode. I'm not sure if I'm the only person. It's okay. You can carry on.
Can I carry on? Okay.
Yeah.
So just a little bit of the content on what we're going to discuss this morning. It's just a little bit of an introduction, the registration of participating employers, the deregistration of the participating employers, and then just some FSCA experiences relating to special rules and participating employee deregistrations. Okay, employer in relation to a fund means an employer participating in the fund. This employer can either participate as a principal employer in a standalone fund or a participating employer in terms of a type A umbrella fund. Registration of employers takes place in terms of Section 12 of the Pension Funds Act. And once that is done, the participating employer gets full, you know, it gets, sorry about that, and the rules of the fund and the Pension Funds Act will apply to that registration. As stated, the registration of a participating employer occurs through the registration of special rules that get submitted to the authority for consideration. A new participating employer starts participating in a type A umbrella fund when the authority approves and register the special rules as stated. And then Information Circular 2 of 27 was implemented to provide clarity on the requirements for determination of participating employers in umbrella funds, as there was some uncertainty in the past on how it should be done. So if we look at the registration of participating employers, registration takes place in terms of Section 12 of the Act through the submission of special rules, which is adopted in terms of the rules of the fund. Some of the minimum requirements that must be in a set of special rules that are submitted to us is the name of the participating employer, and then any subsequent citations. We prefer that the CC, if it's a CC, it must be reflected. If it's a PTY limited, it must be stated, because some of special rules that were submitted in the past didn't give the full citation, and that, yeah, we need the full citation of the participating employer. We also need the physical address of the participating employer. The PO box of the participating employer can be reflected, but the physical address must be reflected. It must also reflect the eligibility of the employees in the participating employer. Who can join, and all that kind of stuff. And it must also reflect the normal retirement age of the members of that fund. It must also reflect the contribution rates of the member and employer, and it must be, can either be a round amount or a percentage of a round amount.